This conference will now be recorded.
And Emily is going to start us off with an introduction.
Yes, well, hello. My name is Emily Lawless, and I'm with Allegiance Home Health. I'm currently in Boca Raton, Florida, where our main office is located, and we serve 89 cities between Broward up into Indian River County. And so Allegiance Home Health is a 5-star Medicare-rated home health agency, and we've also been Home Care Elite for the past 10 years, providing skilled nursing services, physical, occupational, speech therapy, and nursing services. We also provide private caregivers who can assist with meal preparation, Publix runs and errands, doctor trips, and those daily acts of life that we all may need a little bit of assistance after surgery or as we get older. And so I'm happy to be here today with Stephanie, who I actually met about a year ago in our service network, Elder Services Resource Network, where we both bonded on the love of helping others and their families. Allegiance Home Health is family owned and founded off of providing care for our owner, Rosie Martin's mother, and I personally have watched my grandmother take care of my great grandmother and take care of my special needs brother, where Stephanie and I bond over helping elderly and special needs. So that's how I'm happy to be doing this today. And so I moved my screens around, and I need to find. Here we go. Okay, so I'd love to introduce Stephanie. Stephanie Schneider is a board certified elder practicing for 29 years. Stephanie recognizes that clients are multidimensional, and she takes a holistic approach to guiding clients to solutions to aging issues. Stephanie encourages clients to work with a team of professionals to help them achieve their goals and have peace of mind. So thank you, Stephanie, and I will pass it on to you.
Thank you, Emily, for your kind words, and I want to thank Allegiance for this opportunity today to be with all of you. So now I'm going to share my screen so you'll be able to see today's PowerPoint presentation. Okay, is everybody able to see the PowerPoint? Can you go into your chat box and just write me a quick little note to let me know that you can see the presentation? All right, so just so everybody knows, in your upper right-hand corner, you're going to see what looks like a speech bubble, and that is known as the chat box. And you can click on that and you can enter a message. Wonderful, Joya, thank you so much. I appreciate you writing to me. So today's topic is Don't Try This at Home, the dangers and pitfalls of applying for Medicaid and aid and attendance benefits by yourself. So why would you think that it is important to, give me 1 second, to be aware of things before you're applying for government benefits? Well, the reason is that more than ever before, there are individuals and even companies that have in Florida popped up, and they are holding themselves out to the public, saying that they can guide people through these issues. And in reality, they don't have the experience or the knowledge, and as a result, consumers are being injured. So because for some reason, Florida seems to be a hotbed and really attract unscrupulous individuals, I felt that this was not only a timely topic, but especially one we should be talking about, given the fact that the pandemic has caused us all to have to quarantine, And there are individuals who are being preyed upon and taken advantage through email, through phone calls, and being duped. So even if you think the information today might not apply to you right now, I hope that you're going to share it with friends, neighbors, colleagues, people that you know through your church or synagogue, and that you at least take one tidbit of information with you today that can help somebody else. And I think that those of us who are in a giving profession know the importance of paying it forward. So there are 4 things I want to start with to help you understand why you don't want to do this by yourself or rely on somebody that doesn't really know what they're doing. And the first important point is that lack of knowledge and lack of experience is going to result in delay in having an application be approved and might very well cause the person applying to be disqualified. Number 2, these are federal-based laws, and there are additional state requirements. Well, laws and rules can change. And if somebody doesn't do this on a regular basis, they're going to miss something because they don't know that the law or the rule changed. Number 3, yes.
Sorry to interrupt you. We lost the shared screen.
You lost the shared screen. Okay, thank you for letting me know. Let me just get that back. My apology.
There we go.
You're able to see it. Okay, thank you, everybody. Number 3 is probably one of the most important things to be aware of, which is there is no one solution that fits every individual. Every person's situation is different. Their finances are different. Their medical condition is different. Their family dynamics are different. And so solutions really should be tailored to the individual. And this is one of the reasons why I encourage consumers not to listen to what their friend did or somebody they know that they're playing bridge or tennis with, but to make sure they're getting the right advice from a qualified professional. And then last but not least, timing is really important. And you're going to see in a few minutes that Florida decided to change what used to be retroactive Medicaid benefits. And so timing of when an application is filed has become even more important than it ever was before. So I'd like to just briefly provide an overview of what Florida refers to as its statewide Medicaid managed care program. Now, we switched to a managed care program several years ago, and there are still medical requirements. We still have financial requirements. But what they did is they created 2 subparts. So there is the Managed Medical Assistance Program, and that really focuses on pharmaceutical drugs and physician visits, whereas the long-term managed care program focuses on community Medicaid, what we used to refer to as our long-term care diversion program, and our skilled nursing Medicaid program. So the financial requirements we're going to talk about today apply to both community Medicaid and skilled nursing. The financial requirements do not differ. What will change is the medical requirements that need to be met. So somebody who is still capable of performing some activities of daily living, things that we call the ability to eat independently, to groom ourselves, brush our hair, brush our teeth, wash our face, the ability to ambulate either independently or perhaps with assistance using a walker or a cane, our ability to bathe ourselves, and our ability to transfer, meaning to go, for example, from a bed to a chair. If we still are able to perform some activities of daily living, then that individual will probably be appropriate for services offered through the community Medicaid program. Whereas somebody who is not able to perform activities of daily living and has a higher level of need needs to have their needs met through the skilled nursing program. So we're going to begin talking about resources and income and what is the difference between the two. Now you'll see from the PowerPoint that I put an asterisk next to the words marital status matters. So if we have an individual who is single, they are unmarried, perhaps because they're widowed or they're divorced or they never married, their maximum resource limit is $2,000 for countable resources. And in a minute, we're just going to talk about what's considered countable. However, if an individual who needs Medicaid is married, then their spouse who doesn't require Medicaid assistance is currently allowed to keep countable resources totaling $128,640. So you can immediately see that the laws treat a married couple more preferentially than they treat an unmarried individual. The other thing we have to carefully examine is income. So income would be things like our Social Security retirement or Social Security disability. If we have a pension from employment, or perhaps we put money away in an IRA so that the money would be there when we retired, those are examples of income. So Florida is one of the few last states to actually have an income requirement. So I've given you the income requirement for this calendar year. Please be aware that this number is going to change every January. And the numbers change because they take into account cost of living adjustment. Now, what happens if somebody has too much income? Does that mean they just can't qualify for Medicaid? The answer is no, they can still qualify, but there's an additional requirement that has to be met called a Medicaid Qualified Income Trust. So the Department of Children and Families wants to see that this legal document was created and signed, and that a bank account was opened in the name of this trust, and the individual who's applying for Medicaid put into that qualified income trust bank account the amount that their income exceeds the limit. And they don't just do this once at the time of applying, they need to do this every month that they are receiving Medicaid benefits. So my first tip that's really important is that if the income trust is not set up and funded in the month the application is filed, the individual will not be eligible that month. So if they wait until the next month to set up the trust and put the proper income into it, that's when they will qualify. So in planning ahead, which is something I always talk about in my webinars, it's really important that individuals have a well-written, durable power of attorney, so that if they become incapacitated, the person they are entrusting to make financial decisions would have permission to create this trust. We don't want to be in a situation where somebody is lacking capacity and needing to apply for Medicaid, but their power of attorney doesn't include language to create the trust. So when we have that Monday morning quarterback view of what should have happened at Sunday's game, this is something we want to be thinking about and taking care of now rather than later when it might be too late. So when we talk about resources and I work with an individual to examine their resources and see what needs to be done to qualify, I look at and I identify what resources does Medicaid count and what resources does Medicaid exempt. So countable resources are things such as our bank accounts. It doesn't matter the type of account. They will look at checking, savings, money market. They will look at certificates of deposit, U.S. savings bonds, municipal bonds, as well as our investment accounts. So those are all countable resources. However, we live in a really great state, and Florida provides a lot of protections for exempt resources that you will not find in other states in the country. For example, we have very strong homestead protection laws here in Florida, which extend into the Medicaid arena. So DCF will not count the value of the home as long as the value is less than $595,000. What that means practically is that the person applying for Medicaid does not need to sell their home. They can keep it even if they're not living there. Let's say they're getting care in an assisted living facility or a skilled nursing facility. It also means that the home is protected when they pass, so there will be no Medicaid lien against the home as long as the home is going to go to family members. The second type of exempt resource in Florida is the car. So DCF will exempt one vehicle regardless of value, and they will exempt a second vehicle if the age of the vehicle is 7 years or older. Here's another great opportunity in Florida. If the person applying has a retirement account, it could be an IRA, it could be a 401k, as long as they are taking monthly distributions rather than once a year, then DCF will not count the value of the retirement account. That's great. A lot of states don't do this. Now, you probably wouldn't think that funeral arrangements have a value to it, but they really do. So the rule in Florida is that if a person has or is going to purchase pre-need funeral arrangements, they are limited to a value of no more than $2,500. Now that may be enough for people that are considering cremation, but it won't be enough for somebody that actually wants a burial. So if an individual applying for Medicaid would like to spend more than $2,500, they simply need to tell the funeral home to please make the contract irrevocable. And what that means is that should the purchaser change their mind about what they have purchased, the services or the merchandise, and they choose something different that costs less money, the consumer is not going to get a refund of the difference. So this is a way that DCF knows that the Medicaid applicant can't get their hands on cash. So the rule is $2,500, but you can spend greater than that as long as you have an irrevocable contract. Some people receive reparations from foreign governments, including Germany, and these reparations are protected under federal law. There's no time limit for the protection. So what we really want to encourage people to do who are receiving reparations is to keep them in a separate account and preferably not commingle them with other assets that are not reparations, because the reparations are exempt. Now, we talked about the home, but what if somebody who needs Medicaid has another piece of real estate? It's not their home, it's not their primary residence. What do? Well, here are some options. The individual can list it for sale, and it is considered temporarily unavailable, which means that DCF will not count the value. What if the Medicaid applicant owns this property jointly with somebody else? Well, in that instance, if that joint owner refuses to sell the property, it's also not counted, at least on a temporary basis. So we have a lot of wonderful exemptions here in Florida that many people don't know about, and this tends to be one of those areas where people are taken advantage of. So next we're going to talk about minefields, things to watch out for, things that are problematic that will cause somebody either to be delayed in qualifying or be completely disqualified. So many years ago, Congress changed several of the Medicaid rules. And one of the rules they changed is called the look back period. What this means is that when you apply for Medicaid assistance, there will be a question on the application that asks, have you given away or transferred assets? Now the look back is 5 years, but many years ago the look back was 3 years. So because it's a longer look back period, we have to very carefully analyze any gifts, any transfers to best determine when the individual can become eligible. Now, what happens if there are gifts or transfers is the amount of the gift and the date of the gift within the 5 years must be reported. And what DCF does is they apply a math formula which helps them determine how many years, months, weeks, or days the applicant is not eligible for Medicaid assistance. Now, the look back is going to apply when gifts or transfers are made by the individual to someone other than their spouse. And I want to emphasize this. This means they must be legally married. It cannot be somebody that they've been in a relationship with or living together with for a long time. They must be married to get this protection. Medicaid is fine if spouses transfer assets between each other. That's permitted. But when we go outside that marital relationship, those transfers are not protected. The other change that Congress made that you need to be aware of is that when Medicaid calculates the period of time that the individual is not going to be approved, that time frame does not begin to run any longer from when the gift was made. That was the old law. The new law is that clock starts to tick only when the application is filed and the individual otherwise meets all the other eligibility requirements. So this is what is a minefield for a lot of people who don't realize that the law has changed. One of the other major changes that Congress made was now if an individual has an annuity, which is an insurance product some people use as a form of investing and planning for income later in life. If that annuity was purchased after the law changed in 2008, then they can name their spouse, if they have one, as the first beneficiary to receive any monies left in the annuity. But if they're not married, they must name the state of Florida as the first beneficiary. And this is a way that the states are trying to recoup the Medicaid assistance to be available for other people. So let's say that somebody is married, they can name the spouse first, but after the spouse, they have to name the state before they can name their children. Similarly, if they are widowed or unmarried, they have to name the state first, and then anybody else they would wish to name must be listed as a secondary beneficiary. So this is also a trap that people can fall into without understanding what the new rule is. And then last but certainly not least important is last year, Florida applied to the Center for Medicare and Medicaid Services in Washington, D.C., and they asked the government to allow them to not have to provide retroactive Medicaid benefits anymore. It used to be that Florida provided up to 3 months retroactive benefits if you could prove that in each of those prior months you met all the eligibility requirements. So the retroactive benefits was great for somebody who just applied late. They didn't know that they met the standards. Unfortunately, the federal government granted Florida's request, and so we no longer have retroactive Medicaid benefits in Florida. So if you remember at the beginning, I said timing is really more important now than ever, and this is the reason why. If people delay getting the right advice from an elder law attorney, or they accidentally go to somebody who doesn't know what they're doing, and they don't get approved the first time, they're not going to get retroactive benefits, which is very detrimental to a lot of consumers. So these are the minefields I want everybody to be aware of. So now we're going to talk about how does a plan to preserve resources get tailored. You know, we're not talking about doing anything illegal. What we are talking about is maximizing legal rights under the Medicaid laws. For example, since the home is an exempt resource, people can use their excess resources to make home improvements, to make repairs. Perhaps there's a mortgage that they would like to pay off. Those things are permissible ways of using countable resources. Another option that is available to married couples is what is called spousal refusal, and this again is federal law. What it means is that the spouse who does not need Medicaid assistance is on the application stating that they are not going to provide their resources or their income for the care of their spouse. And the spouse who's applying for Medicaid signs a document as part of the application process that says, any rights I may have to support from my spouse, I'm giving to the state of Florida. Once those documents are signed and filed, the Medicaid caseworker is instructed to send those documents to their legal department and proceed to process the application as if the individual is single, is unmarried. So they're looking just at what the applicant owns and what their income is. Now, in states like New York, California, which are very well-funded states, they have strong Medicaid divisions. What they have done over the years is they will send a demand letter to the spouse who doesn't need the Medicaid, and they will ask that that spouse pay a certain sum before Medicaid will pay. In the event the spouse doesn't respond or refuses to pay the sum that has been requested, there have been some cases that actually get filed in court, meaning there's a lawsuit. However, the cases that I have followed do not get to a jury trial. And the reason we believe that does not happen is that the state would know that a jury of the peers of the individual applying for Medicaid would empathize and sympathize with them. And so the state would not get the verdict they want. So these cases have settled for a percentage, meaning pennies on the dollar, of the negotiated amount. And once that is done, the Medicaid application is approved. Here in Florida, we have not seen any cases filed, no lawsuits. They just make sure the documents are properly signed by the right individuals and they process the application. So this is an option that is available. And again, every option has to be right for the individual. We don't just say, oh, use spousal refusal because you're married. We need to look at what the assets are, what their form is, what the value is. We need to look at the ages of the spouses. We need to see, does the second spouse have any medical issues that might become more problematic in coming years? So it's about finding the right solution. Another option that we may consider is if there's an adult child who cared for a parent for 2 years, which helped to delay needing Medicaid, then the home can legally be transferred to that child who was the caregiver. We, of course, need to document, and we do this through affidavits and medical documentation from the treating physician, but this is a permissible transfer. This does not fall within the look back. Another option that might be available to people with the right set of facts is called a personal service agreement. And this is a contract between an individual needing care and a caregiver. It does not necessarily need to be between two people that are related to one another. But what the contract is saying is all the different types of services the caregiver is providing, which might include meal preparation, laundry services, cleaning of the house, overseeing medical care, meaning coordinating appointments, taking the individual to their medical appointments. It might be paying their bills and handling the finances. So what we can do is we can have the caregiver keep a record of what they are doing on a monthly basis and then value that over the elder's lifetime. And whatever number that comes out to will be the actual value that can be paid to the caregiver. So again, this is a plan, this is a tool that does not violate the transfer rule. It doesn't fall within that look back period rule that we spoke about a few minutes ago. If we have somebody that is under age 65, one example is we might have somebody who had a bad accident and they had a lawsuit that settled and they've now come into money, but they have a chronic illness as a result of the accident. They need the Medicaid because without it, they would be paying completely at a private pay cost of care, and that would be depleted before their actuarial life expectancy. So we might evaluate, does it make sense to put the settlement proceeds into a special needs trust? And special needs trusts are exempt under federal Medicaid law. So the monies are there for the benefit of the Medicaid recipient, but because the Medicaid recipient can't control it, they can't directly access and reach into the trust, Medicaid doesn't count it as being available. However, the law from 1993, which gave us the ability to write special needs trusts, does require us to include language that says when the trust beneficiary passes away, any monies remaining in the trust are first to be repaid to the state that provided Medicaid assistance. Then, if there's any monies remaining, then it can go to whoever the beneficiary has indicated. That can be a person, it can be a charity. If we have a client who is over age 65, then we cannot write an individual special needs trust for that client. But their other option is a variation of a special needs trust called a pooled trust. And just as the name suggests, this is an existing trust agreement where multiple individuals can pool, they can contribute their monies from wherever they live around the state into this pool trust. A separate account is maintained for each participant, but the trustee, who is a charity, it cannot be an individual, is allowed to pool the monies together to get a better rate of return for investing purposes. And the trustee, just like a trustee of a special needs trust, must be careful to observe the Medicaid rules or the SSI rules and never put money into the hands of the trust beneficiary, but rather to pay the money directly to a vendor who's providing a service or a product to their trust beneficiary. So they're guided by the same federal laws and rules that govern special needs trusts. And similarly, pooled trusts also have a payback requirement to Medicaid. But these are some wonderful tools that are available for individuals who have chronic illnesses and need to bring Medicaid into their picture. Now, in the beginning, when I spoke about why I chose this topic, I talked a little bit about individuals who are not attorneys but could be professionals holding themselves out to the public and giving advice that is causing consumers to make mistakes and not become qualified, or not become qualified at the earliest possible time for Medicaid assistance or aid and attendance benefits. And some of these individuals include former DCF caseworkers, financial advisors, people that sell insurance products. And here's the concern. Here's what the documented cases have shown. The non-lawyer is the only person communicating with the consumer. Even if they say, I have an attorney who's advising me, or I have an attorney who's going to prepare the legal documents, unfortunately, the client never gets to meet the attorney. So there really is no direct relationship. There's no opportunity to speak to the attorney and ask, is this really the best plan for me? Did you carefully look at all my information? And so even if the non-lawyer is saying they're sharing the fee with the attorney, which by the way is not permitted by the Florida bar, the consumer is being duped. If they're thinking they're saving money by having this non-lawyer advise them and then file the Medicaid application, they're really losing in the long run. So you don't want to trust your future to getting legal advice from somebody that's a non-attorney. Now, this became highly documented back in 2015. And the elder law section of the Florida bar brought this to the bar's attention. And then with the support of the bar, it was brought to the Florida Supreme Court. And there were hearings held, and we actually had clients go up to Tallahassee to testify about the actual harm to the consumers from receiving advice from non-lawyers. So I want to share with you some of the examples of what they testified about. One of the issues that kept coming up over and over again is they had followed the advice given to them by the non-lawyer and never were informed that there were going to be negative tax consequences from a personal service agreement, which under the Internal Revenue Code, when you pay somebody to care for you, IRS views it as earned income. So a lot of these caregivers were not reporting it as earned income on their personal income tax returns. And the elder who was paying the caregiver wasn't paying any employment taxes to IRS either. There were also documented situations about negative tax consequences because people were told to liquidate appreciated stock or appreciated investments, and they were never given tax advice. So after they liquidated, they got hit with a big tax bill. So these are some of the real life dangers that consumers face because these individuals don't know what they're doing. The other big and highly documented case involved a mother and a daughter. And the daughter was advised to say that she was providing services to her mother when she wasn't. And she signed the contract, the personal service agreement. So in reality, this document contained false statements. And when the Medicaid caseworker who was processing the application found out, she reported it as Medicaid fraud. and the daughter was criminally charged, and DCF has decided they will never approve the mother's application again should she refile. So this is pretty egregious, and people are being taken advantage of because they don't know better. Some of the more common mistakes that we saw and that consumers testified about was that the non-lawyer didn't ask them about all their income sources. They didn't check out and see that they were actually over the income limit and they needed the qualified income trust. So they filed the application and then they got denied because the income was too high. Or the non-lawyer didn't carefully identify all countable resources. So when the application was filed and the caseworker ran the applicant's name, date of birth, and social security number through government computers, they found other assets that had not been reported, which does not look good. They assume then that the individual is purposely withholding information, and the application, as you can imagine, was denied. I think probably the most egregious action that these non-lawyers perform is just failing to identify all options and what are the best options for the client, instead of trying to pigeonhole somebody into doing one thing, such as purchasing an annuity, which only benefits the non-lawyer because they're earning a commission from it. So I'd like to just briefly talk about VA aid and attendance benefits, which is a different program. It's different in that it doesn't pay for healthcare services. It actually provides a monthly stipend to the veteran or the veteran's spouse to help them pay for medical expenses that are not being reimbursed by health insurance. And so aid and attendance is a different program than veteran disability benefits, which is meant to provide a financial stipend for people that were injured during their service. For the aid and attendance program, the veteran did not have to be injured during their service, but they must meet a period of wartime service. They must have a certain level of income. And now, as of October 2018, we have some new rules that the Veteran Administration got Congress to pass. So now, despite what the marital status is, a person can be single or married, the maximum net worth, meaning countable resources that they can have, is a little over $129,000. Now, there are some similarities with the Medicaid program, and that was one of the things that this bill was striving to achieve, was to create similarities between the two programs so that when people apply to each agency, they would hopefully qualify for both the Medicaid assistance as well as the aid and attendance. So you can see from the slide that the Veterans Administration will not count the value of the home. It's excluded. Unlike Medicaid, they don't put a value limit on it. And the VA will also exclude the car. However, what's new is now the VA has a transfer of asset penalty. So although the Medicaid rule has a 5-year look back, the VA rule is only a 3-year look back. However, my prediction is that somewhere in the next 2 to 3 years, we will see another bill proposed in Congress that will increase the look back period from 3 to 5 years for the aid and attendance program. So be mindful and watch for that. Now, what we have to prove as far as unreimbursed medical expenses is that the veteran is incurring those out of pocket, which are essentially reducing any income that the veteran has. So the lower the income can be, even if it is in the negative, that shows the Veteran Administration that this veteran or their spouse needs the financial support from the program. So unreimbursable medical expenses can include things like paying for a home health agency, such as the services that Allegiance provides, which Emily talked about a little while ago. It can also be for over-the-counter types of medical items. That could be vitamins. It could be adult garments. It could even be services that are not necessarily covered under Medicare or covered under private health insurance, such as acupuncture or homeopathy. So those are all considered viable unreimbursed medical expenses. Now, if you leave with nothing else today, this is what I want you to walk away with. Because next time you see an advertisement on a billboard or a newspaper, or maybe you're driving around town and you're at a stoplight and you notice a car that is covered in advertisement and it looks really official. It might have a picture of the American flag, maybe the American eagle, and it gives that impression that somehow they are related to the federal government. Here's what I want you to think twice about. Number one, the Veterans Administration has strict rules, and nobody is allowed to charge for assisting a veteran with completing an application. That includes attorneys, such as myself, who are accredited agents, meaning we've gone through training with the VA. Every 3 years, we have to go through additional education and seminars to continue our knowledge base. We as well cannot charge for assisting with the application. What an accredited agent can do is charge for advice that's given, and if the veteran is denied on the application, then once we file the appeal and we go through the appeals process, we can charge for our services. But what you're going to find is when you see these people, non-lawyers and non-accredited agents advertising, they are personally benefiting. They're not helping the veteran. They're helping their own pocket. And many of them are trying to sell a product to the veteran. If you don't know, every county has a local VA office that is staffed by former veterans. Here in Broward County, our office is called the Broward County Elderly and Veterans Services. They do a phenomenal job. I've had clients who are in hospitals or in nursing homes that could not travel to their office, and they will actually come out to where the veteran is and help them fill out the application. They will take the application back to their office and get it filed. And all of this is done voluntarily. There is no charge, and they provide a wonderful service. So please share this information with people you know so that they are not taken advantage of. So I see we are right on time. And so if anybody has questions, please feel free to unmute your microphone and I'll be happy to answer questions. Or you're welcome to type your question in the chat box and I will then read the question out loud and answer it.
You type it. Go ahead and ask.
Hi, Stephanie. Can I do I type it or may I ask you? This is
Oh,
Linda
no.
Brooke.
Hi, Linda. No, please ask it.
Hi, okay. Just a quick, what happens when the primary caregiver is also the executor of the trust, meaning between my mother and I?
Can you be a little more specific as to your question?
Is it a pitfall?
Is it a pitfall?
No, it's not a pitfall.
Okay,
Yeah. Good.
okay. Thank you.
You're welcome. Does somebody else have a question, or perhaps you're hearing things that I talked about today that is different than what you've heard before, or maybe you weren't aware that Medicaid rules and VA rules had changed? Okay, so I'm going to read a question that's just been typed in the chat box. The question is, would a divorced spouse of a veteran who has not remarried qualify for aid and attendance? This is a great question. Thank you for asking it. So the key here is the word divorced. And the Veteran Administration position is that when you divorce a veteran, you divorce the benefits. That has been their position. Now, this is as to aid and attendance, okay? They could possibly take a different position, though I doubt it, as far as other veteran programs, whether it be disability benefits or funeral benefits. But generally, when you divorce the veteran, you divorce the opportunity to access any benefits through the Veterans Administration.
I have a question.
Yes.
I just want to go back to the very beginning when you were talking about income, because you said 2350 for an individual and 4700 a month, right, for a couple?
Correct. So what those numbers mean is if only a single individual is applying, or if one spouse is applying, then you use that lower income figure. But if both spouses in a married couple need Medicaid at the same time and they're both applying, then the higher figure is the number that applies to both.
Okay, thank you.
And I'm glad you asked that question because it gives me an opportunity to clarify something, and that is Medicaid is looking at the gross amount of an income source. So gross means before there's any deduction for, let's say, taxes. Let's say somebody is getting a pension, okay? There might be federal withholding taxes taken out. There might also be a deduction for a health insurance premium through the employer. And we would see this by looking at the stub that comes with the income payment. Unfortunately, we cannot use the net figure. We must use the gross. And sometimes people can literally be $10 or $20 over that monthly income limit. And even though it's such a small amount, they still need that qualified income trust to qualify.
Thank you.
So again, a great question. It's not problematic. It's a matter of that we have to identify early on that the individual's over the income limit, and then determine how do we best get the income trust signed. If the individual is still mentally competent and aware, they can sign it. If they're not, we have to look to see if somebody holds a durable power of attorney that gives permission to create the trust, then we can have that individual sign the trust agreement and set up the bank account. But without this, they could meet all the other requirements, but they're not going to be approved. So the income trust is so important. You don't want to find out about this last minute, especially if you've already filed the application. You know, then you're kind of running behind the clock to be able to get everything done on time. Would anybody else like to ask a question?
Did you answer this question from Dale?
Oh, thank you. I see there's another question in the chat box. The question is, in the case of a young man that is permanently disabled that previously received SSI, which is supplemental security income, but discontinued his SSI and he now needs services, what advice do you have for him? Okay, Dale, I'm going to do my best, but I think I'm going to need to ask you for some more facts first, if that's all right with you. Are you saying the individual voluntarily gave up their SSI, or they lost the SSI because they no longer qualified? Is Dale still with us? There you go. Okay, so you're saying that he voluntarily gave it up. So that's helpful. In Florida, when somebody applies to the Social Security Administration and they are approved for a program called SSI, it gives them a very small financial stipend each month. But what Florida does is once you get approved for SSI, you automatically get approved for basic Medicaid assistance without having to apply to the Department of Children and Families. So when you lose your SSI, either because you give it up or you no longer meet the financial requirements, you're going to automatically lose your Medicaid benefits as well. So a couple of things can be done. Number one, we can look at the reason why the individual chose to give up the SSI. Sometimes people find it's very restraining, especially if they might have some ability to be temporarily or partially employed and earn income. Or perhaps the individual might have inherited some assets that they didn't expect, and it puts them above the $2,000 resource limit for SSI. So really, we would want to start by examining why did they give up or why did they lose the SSI, and what could we do to get the SSI back, which means they would automatically get the Medicaid assistance back without having to go through DCF. So those would be my initial approach to this. But again, it's important to get to know the individual, know their age, their marital status, what is their illness, what is their prognosis, what are their resources and income, to really find the best solution. And sometimes people will qualify for one Social Security program or they'll qualify for a different one. So we want to see, again, what was happening that led them to be qualified for the SSI. The other question I see in the chat box is, do I offer an initial consultation? I do, because without that consult, I can't make recommendations. So everybody who's attending today has the opportunity to either consult with me or provide your clients, your referral sources, with the opportunity to consult. And I would love to extend a 20% discount on the cost of the consult. You can go to my website and you'll see a downloaded gift certificate that you can give to your clients, to your friends or your family. And then what we do is we provide a recommendation at the end of the consult and a proposal, and we will be happy to apply the cost of the consult toward the services. So always know that's there. It's on the website. And I'm really glad you all joined me today. Thank you for taking time out in the middle of your week. I do want to share with everybody to check my website and check my Facebook page. We will be sending out an invitation for a date next week. June is National Elder Abuse Awareness Month, and I am going to be hosting a webinar to alert people to what the warning signs are and what you can do if, unfortunately, somebody you know is already a victim, as well as what you can do to prevent you or somebody you know from becoming a victim. So I'd like to invite everybody to join me for that event. And you're certainly welcome to email me after today's webinar. My address is SSCHNEIDER at FL, the abbreviation for Florida, a hyphen, which is a dash, ELDERLAW.com. And I hope that everybody has a great rest of the week. Please continue to practice social distancing and stay safe. And I hope that you join me again. Thank you.
Thank you, Stephanie.